Welcome to the Explainer. Okay, let's dive into this. Today we're tackling a massive milestone that literally dictates the lives, careers, and futures of thousands of international professionals every single year. We're talking about the green card. We're going to completely demystify the incredibly complex path of transitioning from a temporary work visa, like an H-1B, straight through to permanent U.S. residency. So how exactly do you turn a temporary work visa into a permanent U.S. legacy? That's the ultimate question, right? But right out of the gate, I really want you to shift your mindset here. You've got to frame this journey as a legal marathon, not a sprint. The U.S. Immigration and Nationality Act is incredibly complex. People actually compare it to the tax code in terms of sheer density. So navigating this heavily regulated legal framework takes serious preparation, pacing, and a crystal clear understanding of the rules. To make this easy, here's our roadmap for this explainer. 1. The Green Card Foundation. 2. Decoding the alphabet soup. 3. Clearing the legal hurdles. 4. Navigating common immigration pitfalls. And 5. Your blueprint for success. Let's get right into it. Section 1. The Green Card Foundation. Understanding the basics of employment-based residency. We're going to start with the absolute basics. At its core, immigration law is fundamentally just about categorizing people. Employment-based, or EB residency, is a very specific box. Basically, this is the pathway where the U.S. government looks at your background and decides your specific skills are so incredibly valuable to the economy that you should be allowed to stay here permanently. It's entirely focused on your professional and economic impact. Within this employment-based universe, you essentially have two main lanes. On one side, you have the sponsored lane. This is your standard path. Your employer commits to acting as the petitioner, and you are the beneficiary. But on the other side, you've got the self-petition lane. Think of this as the VIP independent route. If you have a highly specific, high-impact background, the law actually lets you bypass that employer requirement completely and just vouch for yourself. Moving on to Section 2, Decoding the Alphabet Soup, understanding the EB1, EB2, and EB3 categories. And this brilliantly illustrates the hierarchy we're dealing with here. Starting at the very top, we have EB1, the priority workers. This is essentially for the top 1%, folks with extraordinary ability or top-tier multinational managers. And look at that third column, no perm labor certification required. That right there saves you over a year of processing time. Then we have EB2 for advanced degrees, which normally does require a perm test, but it has a really powerful exception we'll cover in a second. Finally, EB3 is for skilled workers and professionals. It's a lot more accessible, but be warned, this category often suffers from some massive multi-year backlogs. Now, remember that EB2 exception I just mentioned? It's called the National Interest Waiver, or NIW. This is an absolutely massive strategic tool. Under the Matter of Donisar framework, if you can prove your work has substantial merit and national importance, USCIS can waive the job offer and that whole perm labor certification process entirely. It's essentially the ultimate middle ground if you have serious talent but really don't want to be tied down to a single employer's lengthy sponsorship process. Section 3. Clearing the legal hurdles. The 3 critical checkpoints. Okay, so we've covered the who, now let's talk about the how. No matter which lane you're in, there are 3 chronological milestones that dictate the pace of your legal marathon. Step 1 is dealing with the Department of Labor for your perm. Step 2 is filing the I-140 immigrant petition with USCIS. And finally, Step 3 is the waiting game with the Department of State for your priority date on the visa bulletin. Let's zoom in on that first major hurdle, perm. Unless you're lucky enough to be in that VIP self-petition lane, your employer has to pass this highly regulated recruitment test. Basically, they have to prove to the Department of Labor that they actively tried and failed to find a willing and qualified U.S. worker for your specific position. Proving a negative to the federal government is pretty much exactly as fun as it sounds. Then, once you actually pass perm and get your I-140 approved, you hit the waiting game. Looking at the visa bulletin here, I want you to think of this like a giant bureaucratic deli counter. Filing your case gets you a priority date. That's your ticket number. Having an approved I-140? Well, that just proves your ticket is valid. You still cannot get your actual green card until the State Department calls your exact number on this final action dates chart. You just have to wait in line. Section 4. Navigating common immigration pitfalls. Reality checks to protect your status. Now, what's really interesting about this section is seeing just how easily a perfectly good case can get completely derailed.
So even if your application is flawless, you can run into serious trouble if you ignore the rules of the road. The first major pitfall is a conflict of intent. Most work visas, like the H-1B or L-1, have non-immigrant intent, meaning the government sees you as being here temporarily. But a green card requires immigrant intent, meaning you plan to stay permanently. Because of this legal friction, you can't just randomly decide to switch statuses overnight without careful, strategic planning.
Aside from that intent issue, you absolutely need to watch out for these three rapid-fire risks. First up, job requirements versus your resume. Remember, the job dictates the category. Actually, think of it this way. You could have a PhD, but if your sponsored job only requires a bachelor's degree, you're stuck waiting in the slower EB3 line. Second is timing. There is a very real risk of your temporary visa expiring while you're literally just standing at that deli counter waiting for your priority date. And third is portability. If you decide to change employers right in the middle of the perm process, you might accidentally reset your entire timeline all the way back to zero.
Section 5. Your Blueprint for Success. Building a multi-year strategy. So what does this all mean for you? So the crucial point is that U.S. immigration is, at its heart, a highly structured, multi-year strategy game. There really is no single one-size-fits-all answer here. Success absolutely depends on perfectly aligning your education, your experience, your specific employer's needs, and navigating the ever-shifting realities of that visa bulletin.
I want to leave you with a question to really think about. Is your timeline perfectly aligned with your immigration category right now? Because if it isn't, or if you aren't absolutely sure, the time to act is right now. This is a journey that heavily rewards early foresight. I highly encourage you to consult with a qualified immigration attorney to map out your own unique strategy. Thank you so much for joining me for this explainer. Keep learning, stay focused on that end goal, and I'll catch you next time.